Section 33 of Tribal Custom in Anglo-Saxon Law. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Read by Kristen Hand. Tribal Custom in Anglo-Saxon Law by Frederic Seebohm. Chapter 14. The Laws of the Kentish Kings, Part 2. 3. The Laws of Ethelbert. The Laws of Ethelbert begin with the heading, "These are the dooms which King Ethelbert established in the days of Augustine." This heading probably did not form a part of the original laws, but it may serve to remind us that ecclesiastical influence must be reckoned with in their consideration, and that some of their clauses may have been modifications of ancient custom rather than statements of what it originally was. The first clause is as follows. Gades feo 7 Circean 12 Guild. The property of God and of the Church 12-fold. Bishops feo 11 Guild. A bishop's 12-fold. Praeosts feo 9 Guild. A priest's 9-fold. Diacones feo 6 Guild. A deacon's 6-fold. Clerks feo 3 Guild, a clerk's 3-fold. Cyric frio 2 Guild, church frith 2-fold. Maple frio 2 Guild, moot frith 2-fold. This clause is read by Thorpe and Schmid and Lieberman as enacting that thefts were to be paid for on this scale, so many multiples of the value of the goods stolen. Clause 2 enacts, give Kyning his laod to him Gehetio, 7 heum mon per Eifelgedo, 2 bot, 7 signi, 50 skillinga. If the king call his laod to him, and any one there do them evil, the bot is 2-fold and 50 skillings to the king. Here are two distinct things. The bot is the payment to the person called to the king. While thus in attendance, any injury is to be paid for 2-fold. The payment of 50 skillings to the king is the mundbeard, or payment for breach of his protection or peace. Clause 3 is as follows. Give Kyning et manes ham drinkeo, 7 per man lesues, hoet gedo twi bot gebet. If the king drink at anyone's ham, and anyone there does something wrong, then let him pay 2-fold bot. That is, the presence of the king at a subject's house is the same as the subject being in the king's protection, and the bot for any wrong done to the subject while the king is there is doubled. Clause 4 enacts, give freemen signi stel 9 Guild for guild. If a freeman steal from the king, let him pay 9-fold. It seems at first sight hardly likely that the archbishop should be compensated 11-fold and the king only 9-fold, but as this is repeated in the statement of the Kentish law in the fragment of Girth and of Mund, the text may be taken as correct. Clause 5 enacts, give in signes tun man manna of slea 50 skill gebet. If a man slay another in the king's tune, let him make bot with 50 skillings. The bot here again is evidently the mundbeard payable to the king for breach of his protection, i.e. 50 Kentish skillings. Clause 6 enacts, give man frigni manen of sleo signe 50 skilling to Drichten beg. If anyone slay a free man, 50 skillings to the king as Drichten beg. Here again the payment is to the king, but in this case, if the word is to be taken literally, it is not perhaps for breach of his peace, but for the killing of his man. He claims it as his Drichten beg, or Lord's ring. It is, to use the later Saxon phrase, the king's man bot, or value to him of his man killed. Up to this point, the question of vergeld has not been mentioned at all, but in Clause 7 is the following. Give signes ambit smeo ape ladrink manen of sleo, Medumen leedgeld voorgeld. If the king's ambit smith, official smith, or a ladrink, outrider, slay a man, let him pay a medumen leodgeld. Lieberman would insert the word man after gif, and so read this clause as stating the vergeld of the king's smith and the ladrink man, when slain, to be a medum vergeld, mittleres vergeld. But the clause is complete as it stands without the insertion of man, and read as it is means that the smith and the outriders of the king, if they slay a man, are to pay a medum leodgeld. But what does this mean? The word medum was translated by Wilkins by Moderata. Thorpe read the phrase as meaning a half vergeld, Schmid as a fit and proper one, and Lieberman would take it to refer to the vergeld of a person of middle rank or position. We must leave the true meaning for the present in doubt. Apart from the amount of the vergeld, if we would understand this passage, we would have surely first to consider for what reason these two royal officials should be singled out from all others and made liable to pay vergelds. The inference must be that in the performance of their duties, they were peculiarly liable to injure others. The king's smith in his smithy forging a weapon, and the outrider forcing a way for the king through a crowd, might very easily, through carelessness or in the excitement of work, cause the death of another. The necessity apparently had arisen to check their action by making them liable to pay a vergeld, but the vergeld was not to be the usual one. It was to be a medum leodgeld. For the present, the exact meaning may be left open, but whether the true reading be a half vergeld or not, the inference seems to be that a full vergeld was not to be paid. Perhaps it had come to be recognized that a person engaged in a specially dangerous trade could not be held responsible to the same extent as in the case of an ordinary homicide. These considerations are important because the medum vergeld will again claim notice, and every hint is valuable when, as in the case of these laws, we have only hints to guide us. In Clause 8, the king's mundbird is declared to be 50 skillings, and the next two clauses relate to injuries done to the king's servants. Gif man viosinges magden man galegio 50 skilling gebet. 10. If anyone lie with a king's maiden, let him pay a bot of 50 skillings. Gif hio grindende peoa sio 25 skilling gebet. Sio pride 12 skillings. 11. If she be a grinding slave, let him pay a bot of 25 skillings. The third class, 12 skillings. Signes fedessel 20 skillinga vergeld. 12. Let the king's fedessel be paid for with 20 skillings. These bots are evidently payable to the king for injuries done to him by abuse of his servants of different grades. They were not vergelds. We have now done with these bots to the king, and the laws turn to consider injuries done and bots due to the earl. Gif on earls tun man mannen afsleho 12 skilling gebet. 13. If a man slay another in an earl's ton, let him make bot with 12 skillings. Gif weo earls berle man galegio 12 skillings gebet. 14. If a man lie with an earl's berle, let him make bot with 12 skillings. And then from the bots due to the earl, the laws pass to those due to the curl. The following clauses show that under the Kentish laws, the curl also had a mundbeard. Curl's mundbeard, 6 skillingas. 15. A curl's mundbeard, 6 skillings. Gif weo curls berlan, man galegio, 6 skillingum gebet. Et per oer peoen, 50 skeda. Et per pridden 30 skeda. 16. If a man lie with a curl's berle, let him make bot with 6 skillings. If with the slave of the second class, 50 skaets. If with one of the third class, 30 skaets. Thus we get a scale of mundbirds, or penalties due for breach of the peace or protection of the king, the earl, and the curl. King's mundbird, 50 skillings. Earl's mundbird, 12 skillings. Curl's mundbird, 6 skillings. But so far, we have learned nothing about the amount of their vergelds. Clause 17 fixes the bot for inroad into a man's ton at 6 skillings for the first person entering, 3 for the next, and 1 for the rest. Then follow an interesting set of clauses, which I think must be read together, as all referring to the case of what might happen in a brawl in which one man lends a weapon to another. Gif man mannen weaponum, bei berep or seus, weerd 7 man naning, effel nan gedep, 6 skillingum gebet. 18. If a man furnishes weapons to another where there is strife, and the man does no harm, let him make bot with 6 skillings. Gif wagrief sai gedan, 6 skillingum gebet. 19. If wagrief, street robbery, be done, let him make bot with 6 skillings. Gif men pone men of sleo, 20 skillingum gebet. 20. If anyone slay that man, i.e., to whom he lent the weapons, let him, the lender, make bot with 20 skillings. Gif men memen of sleo medum leodgild, 100 skillinga gebet. 21. If a man slay another, let him, the lender, make bot with a medum leodgeld of 100 skillings. Gif man mannen of sleho, et openum geref, 20 skillinga for geld 7, in 40 nita elne leod for geld. 22. If a man slay another, let him at the open grave pay 20 skillings, and in 40 nights pay a full leod. Gif bana of land gewetep pamagas, helfne leod for gelden. 23. If the slayer depart from the land, let his kindred pay a half leod. These clauses, taken together and followed carefully, I think, become intelligible. A man lends weapons to another who is engaged in a brawl, and the question arises how far he is to be responsible for what happens in the brawl. In the case dealt with in these clauses, 2 things are involved: the lending of the weapons and the joining thereby in the fray. In the later laws, there are provisions for both points. Under King Alfred's laws, S19, the man who lends his weapon to another who kills someone therewith has to pay at least 1/3 of the vergeld, unless he can clear himself from evil intention. Under Ein's laws, S34, a man who joins in the fray in which someone is killed, even if he can clear himself from the slaying, has to pay as bot, gebet, 1/4 of the vergeld of the slain person, whether twihind or dearer born. Under Alfred, 29-31, the actual slayer has to pay the vergeld, and in addition, each of the others in the fray has to pay as hulubot, 30 skillings for a twihind man, 60 for a 6hind, and 120 for a 12hind man. These later precedents may materially help us in understanding of the Kentish clauses. Clauses 18 and 19 make the lender of the weapon pay a bot of 6 skillings, though no evil be done or only street robbery occur. Clause 20 provides for the case in which the man to whom he lent the weapon was slain, and in this case the bot is raised to 20 skillings. Clause 21 seems to deal with the case of someone else being slain and makes the lender liable to pay a bot of a medum leodgild of 100 skillings for mixing in the fray. It would be natural that the bot should be greater if another was slain than if the man to whom he lent the weapons had been slain. And if the later precedents are to guide us, the bot of a medum vergeld should not in amount equal the whole vergeld, but only a proportion of the vergeld. If the bot of 100 skillings might be considered as equal to a half vergeld, we should gain a clue to what the whole vergeld might be. And this would be a tempting inference, but we are not, it seems, as yet warranted in making it. We must therefore at present content ourselves with the conclusion that the medum vergeld cannot mean a whole vergeld, Otherwise, the lender of the weapon would pay as bot as much as the vergeld would be if he had killed the man himself. Clause 22 makes 20 skillings payable at the open grave and the whole liad in 40 nights. It refers apparently to the actual slayer's liability to pay the whole vergeld, eln liad, and finally Clause 23 states that if the slayer depart from the land, his kindred shall pay half the vergeld of the slain person. We are not told to whom the bot of the medum vergeld of 100 skillings was to be paid, nor whether it was to be a part of the vergeld or additional to the elne liad paid by the actual slayer. The later laws, as we have seen, afford precedence for both alternatives. Another point of interest arises from the last clause. In the absence of the slayer, his kindred had to pay only a half vergeld, helfni liad. Does this justify the inference that in all cases of vergelds, the liability of the kindred was confined to one half? It will be remembered that in the so-called canons valici, supra, page 109, if the slayer had fled, the parentes of the slayer had 15 days allowed for their payment of one half or flight from the country. And only when they had paid their share could the slayer return and make himself safe by paying the other half, the medium quat restat. It seems not unlikely that in the Kentish case, also ecclesiastical influence had limited the liability of the kindred to the half vergeld. Clauses 25 and 26 are important, and we shall have to recur to them. Gif man corleas hlaf etin of sleho, 6 skillingum gebet. 25. If anyone slay a koros halfleita, let him make bot with 6 skillings. Gif leet of sleho pone celestan 80 skillings for gelda. Gif pane oderne of sleho 60 skillingum for gelde. Pain pridden 40 skillingum for gelden. 26. If anyone slay a leet of the best class, let him pay 80 skillings. Of one of the second, let him pay 60 skillings. Of the third, let him pay 40 skillings. To these 3 grades of leets, we shall have to return when we sum up the evidence on the division of classes. Next follow 3 clauses upon edor breach. The first relates to the breach by a freeman of the enclosure or precinct, presumably of a freeman, the penalty being the same as the quarrel's mund. The second imposes a 3-fold bot upon theft from within the precinct, and the third refers to a freeman's trespass over the edor or fence. Give freeman edor broach, gedeo, 6 skillingum gebet. 27. If a freeman commit edor breach, let him make bot with 6 skillings. Gif man in a feo ginemeo, say man 3 gelde gebet. 28. If anyone take property, cattle, from within, let him pay a 3-fold bot. Gif freeman edor gengangio, 4 skillingum gebet. 29. If a freeman trespass over a fence, let him make bot with 4 skillings. After these clauses about edor breach is the following. Gif man mannen afslay agin sket 7 unfakni feo gevilchi geld. 30. If a man slay another, let him pay with his own money, skete, and with any sound feo, cattle. Gif freeman weo frees manus with gelegio his vergeld abici 7 oder with his aginum skete beget. 7 paem odurum et pam gebrengi. 31. If a freeman lie with a freeman's wife, let him pay his vergeld, and another wife obtain with his own sket, and bring her to the other. Then follow chapters relating chiefly to injuries done and wounds inflicted, and the bots payable to the person injured for the same. It is not needful to mention more of these than the most important one, viz., that for the destruction of an eye, hand, or foot. The bots for all these in most other laws were alike. In Ethelbert's laws, the bot for each of the 3 is 50 skillings, which happens to be the same as the munbird of the king. After the clauses for injuries, there are several relating to women. Gif free with lokbor les ves havet gedep 30 skilling gebet. 73. If a lock-bearing free wife does wrong, 30 skillings bot. Majpabat svi swa frigus manus. 74. The maiden bot is like a freeman's. Mund per bestain widuan erlkundre 50 skilling gebet. Dar opre 20 skilling, oare pridden 12 skilling, per feodoran 6 skilling. 75. The mund of the best Earlkund widow is a bot of 50 skillings, of the second rank 20 skillings, of the third 12 skillings, of the fourth 6 skillings. Gif mand widuan unaging gemimp 2 geld seo mund sai. 76. If a man carry off a widow not in his mund, her mund shall be twofold. The clause relating to the mund of the 4 grades of apparently Earlkund widows does not help us much to an understanding of what the grades of Kentish society may have been. But it emphasizes a remarkable trait of these laws of Ethelbert. Every class is divided in these laws into grades. The clergy are divided into grades from bishops to clerks. The female servants of the king's household are divided into 3 classes, and so are the servants of the ceorl's household. The layates are divided into 3 classes, and now the widows, whether all Earlkund or not, are divided into 4 classes for the purpose of their mund. The significance of these divisions will be apparent hereafter. In the meantime, the mund is probably the amount to be paid by a second husband to the parents or kindred of the widow. Passing from the mund of the widow, the following clauses throw some light upon the positions of the wife under Kentish custom. Gif mon majp gebegio keapi gekehapad sai gif hit unfakni is. Gift it pone fakni es f per et ham gebrenge 7 him man his skeet agef. 77. If anyone buy a maid, let the purchase stand if without guile. But if there be guile, let him bring her home again, and let them give him his money back. Gif hio quick bairn gebrip helfni skeet age gif curl sveltip. 78. If she bears a living child, let her have half the property if the husband die first. Gif mid bernam bugan will helfni skeet age. 79. If she wills to go away with her children, let her have half the property. Gef Carol Egan Weil Swa and Bairn. 80. If the husband wills to have them, let her have as one child. Gef Hio Bairn ne Gebrep Fadering Magas Fio Egan 7 Morgan Fife. 81. If she bear no child, let her paternal kindred have the property and morgan gift. It is obvious from these clauses that under Kentish custom, the position of the wife was very much the same as under Cymric and continental German custom. The marriage was a fair contract between the 2 kindreds. The next clause enjoins a payment of 50 shillings to the owner of a maiden if she be carried off by force. Lastly, there are the following clauses relating to the position of the esne under Kentish custom. The esne is considered to be a servus working for hire rather than a theo. Gif man mid esnes quien gelip be quickum corle to gebet. 85. If a man lies with an esne's wife, the husband alive, double bot. Gif esne operne afsle unsinnigi elne werde forgeld. 86. If one esne kills another innocently, let the full worth be paid for. Gif esnes age 7 foot of werodep aslagan elne werode hein forgeld. 87. If an esne's eye and foot are struck out or off, let the full worth be paid for it. Gif men manes esne gebendep 6 skillings gebet. 88. If a man binds a man's esne, 6 skillings bot. There is nothing in these clauses, I think, to show that the bot was payable to anyone but the owner of the esne. What the full worth of the esne was, we are not told. 4. The laws of Hothlater and Edric, A.D. 685 and 6. Between the date of the laws of Ethelbert and those of other Kentish kings, which have been preserved nearly a century, had intervened, so that these later laws of Kent are nearly contemporary with King In's dooms of Wessex. As in Ethelbert's laws, the main division of classes of freemen seems still to have been that between Earlkund and Corlys. But we get further valuable information. The laws of Hlothere and Edric open with the clauses which seem to fix the vergeld of the earl at 3 times that of the ordinary freeman. They deal with the liability of an owner of an esne for his servants' homicides. Gif manus esne Earlkundni mannen of Sleho, pene pe sio preum hundum skilling gilde se agend pon bannen a gef 7 du per prio manwiro 2. 1. If anyone's esne slay an Earlkund man, one that is paid for with 300 skillings, let the owner give up the slayer and add 3 manworths thereto. Gif sebana odbirsti feordi manward he tegedo 7 hein gekenen mid godum awadum p he pane banem begetten nemeten. 2. If the slayer escape, let him add a 4th manworth, and let him prove with good compurgators that he could not catch the slayer. The next 2 clauses are as follows. Gif manus esne frigne mannen of sleo, pene pesi hund skillinga gelda se agend pone bannen a gef 7 oper manword pertu. 3. If anyone's esne slay a free man, one that is paid for with 100 skillings, let the owner give up the slayer and a 2nd manworth thereto. Gif bana odbersti tam manwedrum, heine man forgeld 7 heine gekan, mid godum awedum pe he pan bane begetten ne mitte. 4. If the slayer escape, let the owner pay for him with 2 manworths, and let him prove with good compurgators that he could not catch the slayer. The reading of these clauses is not that of Thorpe or of Schmid, but that approved by the best authorities. Following this reading as philologically the most correct one, the inference at first sight might be that under Kentish law, the vergeld of the Earlkund man was 300 Kentish skillings, and that of the free man 100 skillings. But there may be reason to doubt the correctness of such an inference. For the present, we may leave the question of the amount of the vergelds to consider the meaning of the clauses and their main intention. And this seems to be clear. Henceforth, the owner of an esne was not to be accountable for the vergeld of the person slain, or any part of it further than that if an Earlkund man payable for with 300 skillings be slain, he must hand over the esne and 3 times his manworth in addition. And in the case of the freeman payable for with 100 skillings, he must hand over the esne and add 1 manworth in addition. That is to say, the esne was in both cases to be handed over in a manworth for each 100 skillings of the amount at which the person slain is paid for. Now I think we must conclude that these clauses were intended to make an innovation upon ancient custom rather than to confirm it, and therefore it may be well to compare with them the parallel evidence of the laws of other tribes as to the responsibility of an owner for his slaves' homicides. Under the Welsh laws, 2, page 105, the liability of the owner of a slave for his homicides was apparently complete. If a bondman commit homicide of whatever kind, it is right for the lord of the bondman to pay for the deed of his bondman as for a murderer, for he is a murderer. And this probably must be taken as the general rule of tribal custom in its early stages. In the laws of the Saxons and of the Angli and Verini, the ancient German tribal custom was still preserved. The owner of an animal or a slave was liable for any injury done by either, very much as if it had been done by himself. Lex Sax 7, Ang and Ver 16 and 52. But it would seem that Roman and Christian feeling very early suggested that this was hard upon the innocent owner. Hence, in some of the laws, the compromise was made that the owner should pay only a half wehrgeld and hand over the offending animal or slave instead of the other half. That this innovation was not altogether acceptable to tribal feeling is shown by clauses in the Pactus III of the Alemannic laws. The whole wehrgeld was to be paid by the owner if his horse, ox, or pig killed a man, S. 18. But an exception was made in the case of the dog. If a man's dog killed anyone, a half wehrgeld, medium wehrgeldum, was to be paid. And if the whole wehrgeld was demanded, all the doors but one of the house of the person making the demand were to be closed, and the dog was to be hung up 9 feet from the only one left open for ingress or egress, and there it must remain till it fell from putrefaction. If it was removed or any other door was used, the wehrgeld was to be returned. S. 17. Grimm, Dr., page 665, has pointed out that in the Ostgotalaga, Drap 13.2, a similar archaic practice is described when a slave had killed a man. The owner of the slave under his law ought to pay the whole wehrgeld, and if he did not do so, the slave was to be hung up at his, the owner's, house door, till the body putrefied and fell. Thus, the same archaic method of punishing the delinquent was retained in both cases. But the significant point is that so long as the whole wehrgeld was due from the owner, it was at the owner's door that the body of the slayer was to be hung up, while when the half geld only was to be paid, the dog was to be hung up at the door of the person who improperly demanded the whole wehrgeld. Thus, as in so many other cases, the 12th century laws of the North preserved the earlier custom of the payment of the whole wehrgeld, while the Alemanni, after migration into contact with Roman and Christian civilization, in their laws of the 7th century modified the custom, at the same time retaining the archaic method of forcing compliance with the modification. It must be remembered that every change which relieved the innocent owner from liability, wholly or in part, robbed the kindred of the person slain of the whole or the part of the wehrgeld. The compromise of payment of the half wehrgeld and the handing over of the offending animal or slave was not confined to the Alemannic laws. In the Ripuarian Law 46, the animal which had killed a man was to be handed over and received in medietatem wehrgildi, and the owner was to pay the other half. In the Lex Salica, the same rule was at first applied to the case of homicide by a slave or layet. A half wehrgeld was to be paid, and the slave or layet handed over for the other half. This was the rule according to the Codex 1, but in the later codices 7 to 10, and in the Lex Edmundata, the lord, if innocent, was allowed to get off altogether from the half wehrgeld, and had only to give up the slave or the layet. This further innovation seems to have been connected with the Edict of Chilperic, circa AD 574, and thus probably represented the result of ecclesiastical influence at very nearly the date of the earliest Kentish laws. We have only to recur to the canons of the Celtic Church of Brittany and South Wales of the 6th and 7th centuries, considered in the earlier part of this volume, to recognize the hand of the Church in these innovations upon earlier tribal custom. They extended to Celtic as well as to German districts. In Canon 5 of the so-called Canones Vallici, the rule was laid down that if any master should permit his slave to carry arms, and the slave killed a freeman, the owner must hand over the slave and another besides. Supra, page 108. The half wehrgeld here is omitted altogether, and, as in the case of the Kentish freeman, 2 slaves are to be given up instead of 1. These canons were nearly contemporary with later Kentish laws, and the same stage of innovation seems to have been reached in both. A still further and final stage had been reached in the Burgundian law already quoted, Supra, page 124, in which, in the case of homicide by a slave unknown to his master, the slave was to be delivered up to death and the master was to be free from liability. The parentes of the slain person were to get nothing, not even the slave, because as we enact that the guilty shall be extirpated, so we cannot allow the innocent to suffer wrong. The whole process of change had taken place in the Burgundian district by the 6th century, but it would seem that in Kent the middle stage had only been reached at the date of the laws of Lothair and Edric. Evidence that the further stage had at last been reached in Anglo-Saxon law is perhaps to be found in the nearly contemporary law of Ine, S. 24, which enacts that if a Theowealth slay an Englishman, the owner shall deliver him up to the lord and the kindred, or give 60 shillings for his life. Here no further manworths are required, but possibly the peculiar position of the Theowell may have something to do with it, so that we ought not perhaps to assume as certain that the clause represented a still further general innovation upon tribal custom beyond that described in the Kentish clauses. Returning to the Kentish clauses, and assuming that their direct intention was to modify previous custom, we are now in a position fairly to judge what the previous rule may have been. Reasoning from the analogy of other laws, it seems most likely to have been to make the owner pay a half vergeld of the person slain, and hand over the esne for the other half. The stage of custom reached in the Ripuarian laws and Salic laws of Codex I. And if this were in fact the former custom previous to the enactment in these clauses, then without departing from the correct literal reading of the text, it may be that the words in the parentheses in each clause may refer not to the Erlkendmen's or the freemen's vergeld, the word leodgeldi is not used, but to the amount hitherto payable in the particular case of a man slain by an esne. The 300 and 100 skillings may be the half vergeld hitherto payable, instead of which thenceforth the owner of the esne is to pay 3 mansworths, or 1 manworth, in addition to handing over the esne. If previous to the innovation the Erlkendmen had been paid for in such a case with 300 shillings, and the freemen with 100, the words in their strictly correct literal meaning might perhaps rightly be read thus: If anyone's esne slay an Erlkendman, one who is now paid for at 300 skillings, let the owner in future give up the slayer and add 3 manworths of the esne thereto. If anyone's esne slay a free man, one who is now paid for at 100 skillings, let the owner in future give up the slayer and add 1 manworth of the esne thereto. This reading of the clauses, putting emphasis upon what is now the guild, Bain Bay C, the 3 and the 100 skillings, in contrast with what the owner has in future to do, i.e. pay 3 manworths and 1 manworth, instead of the 300 and 100 skillings, in addition to the handing over of the esne, seems to me more than any other rendering to account for the insertion of the parentheses stating the amounts payable for the Erlkendmen and freemen. If the word leodgild had been used, it might have been different, but I am informed on the best authority that the words gild and geld in the 2 clauses are not substantives, but used in an adjectival sense, and in this case they would apply to a half vergeld payable as correctly as to a whole one. At the same time, the mention of 100 skillings, if the payment be a half vergeld, may help to an understanding of the medum leodgeld of 100 skillings mentioned in Ethelbert's laws. It suggests that the medum vergeld was a modified or middle one which, like the medium vergeldum and medium precium of the medieval Latin of the Alemannic and other laws, had come to mean a half one. Perhaps, after all, if we recognize clerical influence in the framing and modification of Kentish laws, the translation of the Latin medium vergeldum by the Anglo-Saxon medum leodgeld is not very unnatural. Before we leave the laws of Lothair and Edric, there are 1 or 2 further clauses worth notice. Clause 5 reminds us that though scarcely mentioned in these laws, the system of compurgation was in force. A freedman charged with a crime has to clear himself by the oaths of a number of free awad men. Clause 6 makes mention of the protection of a woman by her kindred. Gef Carol Aquili be lebendum wife 7 bairn, right is p het p, bairn meder, folgage 7 him mon, and his Fadring Magum Vilsume Berrigan, Gesell his Feo to Helden, Apat he 10 Wintra C. 6. If a husband, Carol, die, wife and child yet living, it is right that the child follow the mother, and let that sufficient guardian be given to him, the child, from among his paternal kinsmen to keep his property, cattle, till he be 10 winters old. These clauses, unimportant perhaps in themselves, are useful as showing that behind the silence of the laws, tribal custom still lingered on. However seldom and slightly it might be brought into evidence, as fresh circumstances might suggest new clauses. There are also some clauses which are useful as showing the continuance of the mundbirds of the king and curl of King Ethelbert's laws, unchanged in amount a century later. By S11, if a man uses abusive words to another in anyone's flet, let him pay 1 skilling to him who owns the flet, and 6 skillings to him to whom he said the words, and 12 skillings to the king. So also in S12, 1 skilling is to be paid to the owner of the flet, 6 skillings to the person wronged, and 12 skillings to the king. The 6 skillings to the person insulted or wronged is the mund of the freeman or curl. Lastly, in S13, in case of a slaying in a drinking bout, gif man weapon breged per main drinken, 7 per man nan ifil ne ded, skilling pan pay flate, age 7 signy 12 skilling. If a man draw a weapon where men are drinking and no harm be done, then a skilling to him who owns the flet, and 12 skillings to the king. Gif pay flet geblod gad, word vergeld pem main, his mund beard 7 sig 50 skilling. If the flet be stained with blood, let him pay to the man who owns the flet his mund bird, and 50 skillings to the king. Thus we have again the mund birds of King Ethelbert's laws. Of the king, 50 skillings. Of the curl, 6 skillings. The crime of killing another in a drinking bout is a breach of the mund of the owner of the flet, as well as a breach of the peace of the king. End of section 33.